Good morning, Mr. Davenport. Please take a seat. I understand you've come in to see me because of a share purchase which you now regret. Is that right?
Yes, that's right, Mrs. Jones. I bought shares in a private limited company in 2017. I'm afraid I've made a terrible mistake, which is why I'm here.
This is an investment you recently made in a company called, Invest Supreme Limited. Is that right?
Yes, that's right. I wish I'd never heard of them. I really do.
Well, why don't you start by telling me something about the company? What type of business is it?
Okay, well, they search for houses that are for sale, which have good potential for improvement. Once they find a house like that, they sell it to one of their clients. The clients are all professional property developers.
I see. So they find a house, a client buys that house, carries out improvements, and sells it for a very decent profit, and Invest Supreme Limited receives a proportion of that profit, I assume.
Yes, they receive 7.5% of the net profit, which I was promised would translate into very good dividends.
And how did you become involved with the company?
I was at the birthday party of a colleague, Anna King, where I was introduced to Anna's brother-in-law, Kevin Hamilton. He's one of the directors. There are two other directors, but I've never met them. Kevin told me that the company was going from strength to strength and they were looking for investors.
What did he propose exactly?
He said that the directors were about to issue new shares in the company to bring in 10 new members. Each of the new members would buy one share representing a 1% stake in the business. He made it sound like a golden opportunity with dividends as good as guaranteed because of the boom in housing market.
And how much did he want from you in return for this 1% share in the company?
£12,800.
OK. And did you do any background research on the company before you handed over the money?
Yes, I checked the information that was available on the company's house website, right back to when the company was formed in 2014. It all looked in order, as far as I could see.
So, when did the trouble start?
When I saw the accounts filed in April 2018, the company was in the red. I couldn't believe that it made a loss. When I went to the AGM in June, which they held at the Grand Hotel in Brighton, I was ready to demand an explanation. But I didn't get one from the directors. Instead, I got some shocking information from another new shareholder, Anton Lewis.
And what was that?
He told me that one of the directors, John Appleby, wasn't playing by the rules. Apparently, Mr. Appleby's been buying up the best properties for himself rather than passing them on to clients. So, no commission is being paid, but the business still has fixed costs. For example, the rent on their offices on Bond Street was more than the total income for the year. And I've heard rumours that all three directors have paid a fortune for flights in the last year, including trips to Paris and Venice. How can they possibly justify that? Is that where my money's gone? I'm just speechless.
Have you raised these issues with the directors?
Yes, I wrote to them at the registered office address and told them exactly what I thought of them.
I see. And how did they respond?
Not well. John Appleby said that my comments were defamatory, whatever that means, and he planned to take legal action if I repeated them. Well, what can I do? They won't even listen to my concerns.
Naturally, you want to protect your investment, but the first thing we need is evidence. Once I have all the relevant paperwork proving the facts you've given me so far, with particular emphasis on the director who is buying up properties himself, I can raise the issue of fiduciary duty.
That sounds serious. What does that mean?
It means that as a director, he must act in the best possible interests of the company, selling properties himself and not declaring the resulting profit is a conflict of interest and breaches his fiduciary duty. It's justification for removing him from this position as director, which is what I would advise them to do, as well as requiring him to account for the profits.
But what if they refuse?
Then I'll need to check two documents which we can easily obtain. Their articles of association, which I can get from Companies House, and I'll also need to see your share purchase agreement. I'll inspect both documents for clauses dealing with the removal of directors, and we can also rely on the Companies Act 2006 if necessary.
What does the Companies Act say?
Well, under Section 168, the company members can remove a director by passing an ordinary resolution. This is provided that the members represent at least 5% of the company and put forward the proposal at a general meeting. Don't worry, we'll get to the bottom of this fairly quickly, I think.
Thank you very much. I'll leave it with you and wait to hear from you about where we go from here.
OK, thanks for coming in, and try not to worry. I'll be in touch.